You're listening to Choose FI Radio. The blueprint for financial independence lives here. If you're looking to unlock the secrets to financial independence and early retirement, you're in the right place. Stay tuned and join a community of like-minded people who are getting off the hamster wheel and taking control of their lives in the pursuit of financial independence. Choose FI, your home for financial independence online.
All right, hello and welcome to the show. On today's episode, very excited. We're going to be exploring this idea of estate planning a little bit farther. In episode 125, we brought Chelsea Brennan on the show talking about the family emergency binder, talking about the importance of creating a resource for, in the very worst case scenario, your survivors, but honestly, any run-of-the-mill emergency, a document in place that your family and those around you can use to figure out what steps should we take. But at the end of that episode, she said, honestly, a key part of this is having in place an estate plan, whether that be a will or a trust. And we wanted to go a little bit deeper, so we looked to our community and we asked Mark Moss to join us on the show today to talk to us about how to build a solid estate plan and all of the components of that plan. And to help me with this, I have my co-host Brad here with me today. How you doing, buddy?
Hey, Jonathan, I'm doing quite well. And yeah, this should be great, especially in light of last week's episode with Chelsea. This goes hand in hand. It's just such an essential piece. A lot of us, we just don't think of this. I mean, really, it's an uncomfortable subject to think about your death, but it's so crucial to plan for those around you, your loved ones, and to not leave them really holding the bag with no idea what to do, right? And that's the beauty of both the family emergency binder and, like you said, a solid estate plan. And who better to ask than someone from our community? So with that, Mark, welcome to the podcast.
Thank you guys both very much. Happy to be on here. Been a big fan, longtime listener, and just happy to be on here and make the uncomfortable comfortable.
Mark, let's go ahead and start by talking about who is this for? I think many of us at first hear just that, that phrase, estate planning, and think this is for the uber rich.
Absolutely. And that's something that I come up against day in and day out, that I don't have enough to need an estate plan. But really, estate planning is for everyone over the age of 18. They should take a look at it, should have some aspect, if not all of the documents that we will talk about in place for themselves.
All right, Mark. So as you're saying, basically any adult age person should have a will. But just give me like the 15-second elevator pitch of why. Is it to save time? Is it to safeguard assets? Like just real high level, what would be the purpose for someone who hasn't previously even contemplated a will?
So yes is really the most succinct way to answer that question, but having it is to save time, really let your wishes be known, and as best as you can, a trust does it better, and we'll get into that later, but it helps avoid potential fighting, court costs, and additional litigation and fighting.
So Mark, let's slow down just for a second and talk about your personal money story. You're an attorney. How did you become interested in estate planning?
Yes, I am an attorney, and this is my primary practice area, but as far as my money story, it started with, realistically, an estate plan that I was a beneficiary of when my grandparents passed away when I was younger. And luckily for me, my parents invested that wisely. And we all know what happened with the stock market in the late first decade of 2000s, '08, and everything came back. I was invested after that, wrote it up, and took out law school loans, was able to liquidate a portion of that portfolio to pay off not all, but a portion of my loans, and enabled me to kind of continue on that journey prior to finding FI, of buying the best house that we could get approved for and all of that.
So Mark, with that money that you inherited, is that something that actually was in some type of trust where there were requirements on how to spend it or when you could spend it? Or was this just, hey, let's give it to Mark and he has unfettered access to it?
It was not any sort of trust. All of the grandkids got a small check. And like I said, luckily for me, my parents invested that. And the market, I had the good fortune of, I'm not going to say market timing, but I was fortunate in when it was invested and what the outcome was.
All right. So just to clarify, as part of your grandparents' estate plan, you receive a relatively small lump sum of money that's invested in the market. And what you're saying is it effectively was invested right at the bottom of the market. So, circa 2012. And then you ride this out for the next several years and you're able to use that capital appreciation to pay for a portion of your law school student loans. So law school, I believe, is an additional 3 years after undergrad. How much student loan debt did you graduate with?
just under 70,000 at almost 9%. And those were just the private loans. Federal, I'm going to ballpark at probably 30 to 40.
So you're graduating with roughly $100,000 in student loan debt. You have a law degree. You're now a practicing attorney. And, you made a slight reference there to lifestyle inflation. I'm not totally surprised. When I think about professions that are particularly susceptible to lifestyle inflation, doctors and lawyers, in my mind, are kind of one of those first few that show up on that list. How did that manifest in your own life?
So it actually took a while to manifest in my own life. I had the same car when I turned 16 I had up until about 4 years ago. It's not as old or classic as Golden Boy, but I was striving for that and wanted to make sure we get a reference to Golden Boy in here.
Done.
Of course.
But it's one of those things, again, you think, okay, I've graduated, I have all this debt, I'm going to make all this money, I can spend it, it's going to come in. And then you realize, well, it doesn't come in as fast as you think. And you have your loans to pay on, and there's no exception to payments being made on those loans. You have to start making adjustments.
So Mark, with that type of debt, do you remember roughly what the monthly payments were? Did you have that $70K at 9%? Like, is that one payment and then the federal is another payment, or are there more than just two payments? Like, talk me through the actual debt and like what that looks like on a monthly basis.
Really, I wish I'd found this show sooner, thinking back to the episode you guys did with Travis from the Student Loan Planner. But I believe it was two separate payments to answer your question, one on the private, one on the federal. And I believe it was about $700 or $800 a month. But then when I refinanced, like I said, that payment changed and basically cut my rate in half and brought it down to just one single payment.
Well, that sounds pretty good. So once you consolidated, what was the interest rate that you ended up getting on that combined? Because you started out with a blend of 70,000 at 9%, and the federal, I believe, was probably going to be a little bit lower, but I would imagine, 6% or less, 4 to 6%, somewhere in there.
That sounds about right on the federal. When I refied, I'm at 4.84.
Nice.
Really happy with that one.
Yeah. I mean, I think as long as you have a plan to pay it off, that actually could have been a pretty good choice for you. Surprisingly, in the 200 plus episodes that we've done, I think we've only spoken with one other attorney up to this point, and we really didn't go into kind of the wage range for new attorneys in the field. And I realize that there are hundreds of different types of practices out there and focuses and specialties, but what is the expected range for a lawyer going into that field today?
When I think too, there is a huge range. And I think that range not only depends on the practice area, but depends on the geographic location. It's come up multiple times on the show, for whether it's urban, whether it's rural. But I would say a ballpark, and whether you're in private practice or working for the state, could be anywhere from 40 to 45 up to six figures starting out.
Wow. So 6 figures would be like a white shoe law firm in New York City or DC or something like that. But 40 to 45 are you saying that's like a realistic starting figure for a law school graduate, like in many parts of the country?
Absolutely. That's what I'm seeing. And especially, and that would be more so with the government or working for the state than it would be in a private practice. But there are some private practices that will start first year attorneys out in that range.
Wow. So people are going through 7 years of schooling with undergrad and law school, and then taking out all this debt to be a lawyer, right? Which is making it in America, right?
Correct.
And only making 40 to 45K. Wow. That's really surprising to me. I didn't realize that.
So that's, again, to your question with the lifestyle inflation, everyone just assumes, oh, you're an attorney, you must be rolling in the green. Not always is the case.
And if at the same time you feel the press, so in order to work up the ranks, right, and to make it from that 45K to that 6-figure salary, and on top of that, you kind of have this imposed, whether it be self-imposed or externally imposed, need to appear like you've made it. In order to make it, it really holds you back from making it, for lack of a better word. So that's keeping up with the Joneses for lawyers is brutal.
Yeah, and that's why, to be honest, I've stopped trying to keep up with the Joneses and just paid attention to what I'm doing and what I can control.
Well, let's talk about that light bulb moment, because you mentioned earlier that you were an impulsive spender. How did you rein that in?
Well, I would never have classified myself as an impulsive spender. Others might have, but really reined it in, again, just looking at the inflow and outflow of assets and what sort of position am I putting myself in individually. And then as I got married, started to grow a family, what sort of position am I leaving? And to get, to what we're talking about again today, what's the legacy I'm going to leave for myself, for my family, for future generations? And things needed to change if I wanted to leave a positive one.
All right, Mark. So this doesn't sound like the most optimized path for a lawyer to come out with a 40, 45K salary, all those years of opportunity costs, plus the debt. Like, is there anything that that you could pass along? You know, we're always looking for actionable information and advice for the audience. You're on the other side of this. What would you have done differently? Have you seen other people do anything interesting that you would pass along and say, wow, I wish I had done that, or I would advise you to do that?
Absolutely. I mean, firsthand myself, you have the student loans, you have that disbursement that comes in. If you're not spending it all, you don't need to go out and take an extra road trip, go on a vacation. Just put it back in, just pay it off immediately. Yes, you have that money now, but you're going to pay for it 10 times more down the road in the future that I wish I really thought about initially. Kind of one of the jokes in school is, well, I'll pay for it someday, somehow, but right now I don't have to worry about it. I think that's a big regret. But it's one of those things that going into school, a lot of people tried to talk me out of going to law school, but I knew this is what I wanted to do and I wouldn't listen to that. Now, when I have friends that are thinking about going to law school, I'm not trying to talk them out of it, but I make sure that the wool is not pulled over their eyes and that they see here's the reality of it. It's no longer come out of school, get a 6-figure job with a huge signing bonus and life is great. You have to really want it and grind out. And there may be a better path to go with less debt unless it's something that you really want to pursue.
So you have your own practice now and you're doing estate planning and probate, which is going to be the focus of this conversation. But I would imagine that on day one, it's hard to just graduate and go straight to your own practice. What was the transition there?
Absolutely. I mean, there's some people that do it, but it was not something that I wanted to pursue or necessarily had the means to do as well. Right after law school, I graduated actually with a job offer from a large corporation here locally and went in their compliance department, worked there for a few years and transitioned out to operating my own firm.
Yeah, Mark. So, I mean, you make it sound pretty easy in hindsight, right? But like actually getting the nerve up to start your own firm and leave the place where you are and a steady paycheck. You said you have a family. That's not as easy as it sounds, right? So talk me through the thought process and how you went about transitioning to your own firm.
So absolutely, it was not an easy decision by any means. Looking back now, it seems easy, but no, going through it, it was far from that. So luckily for me, I had some savings as well as 401k, IRA, and my wife was working as well. So as I was growing the business, if need be, I wasn't paying myself. We were getting by on my wife's salary if we needed to dig into savings, but I also could take a loan from my 401k if I needed to, or just take a distribution from there and justify it's worth the penalty to make sure that we can pay the mortgage.
So you're keeping the lights on and you're growing this business from the ground up. You have some savings in place to kind of, make sure you can keep the lights on in the process, but now you're getting to do what you're really passionate about, and that is estate planning. And so let's go ahead and take this second half of the show and talk about that process, what people need to know. And I think some interesting subtext here is that Brad and myself both had our wills done. And we have just gone through this process. And I think both, in my case, Brad, I'd actually love to get your feedback. In my case, this is something that my wife had been telling me that we needed to do for probably well over 2 years. And I had been kicking it down the road. And then honestly, because of the show, because of the conversations we were having, I was like, okay, we're going to do it and we're going to do it right. So it's finally done. And I'm really, really excited about it. And I think we have something to talk about here, but you got yours done as well, right, Brad?
Yeah, I definitely did. And actually this was an update on an older will and set of estate documents that I had. To your point about Danny asking you, I think it was both Laura and myself, we felt that it had been probably over a decade. I think basically, when my older daughter, Anna, was born, about that time. So about a decade that we had the original documents drafted. And we wanted to just go through them, make sure they weren't hopelessly outdated. And mostly that our current instructions and our current intentions were in there, right? Because that's the important part. So, Mark, I'd love to talk about when a client comes in, what are the first things you talk about? What are you trying to get to know? Do you have to understand like where they are, where they're going? How much do you talk about them personally?
Absolutely. I would say probably 80% of the conversation is about them. Obviously, there's a portion of it that's about their assets and what we're transitioning. But the way that I do it personally is I have a questionnaire that I have them fill out prior to meeting with them. That way, I'm not going into it blind. A lot of people come up to me, call me, how much does it cost for a will? How much is a power of attorney? I don't know your situation, your goals, how many children you have, how many marriages. It's hard to say. There's not a one size fits all approach.
Yeah, that makes sense. So it's a questionnaire. Do you have a sit down meeting or multiple meetings? Because ultimately conversations about money, conversations about what to do with your children if you happen to pass, like these are difficult conversations. almost to the point where people might need a therapist or a marriage counselor. I mean, these are real serious conversations. Do you help facilitate that? Do you have things that you tell them to talk about? Talk me through this, because like you said, this is 80% of what you do.
Right. So absolutely. So we go from that questionnaire, we go through, and it's questionnaire is somewhat surface level, and that's almost to be expected, I feel like, just because if I go too in depth, you'll never complete it because it's such deep conversations and important things that people don't really think about or enjoy talking about. But that's we go through in depth, and it is facilitating that conversation. And it's not something that you, the potential client, thinks about every day, but it's something that I do. And oftentimes I hear, wow, I didn't even think about that. Is that really the case? Could this happen? Well, this may not actually happen, but it could. We want to make sure that we're prepared, because why are we planning if we don't cover all bases?
What's so interesting is when I think of a will, I think about who's going to get my stuff, which sounds pretty basic. Like, why do we need to bring an extensive legal document at all this? Like, hopefully it works. If it doesn't, big deal. But what I've realized as a father is that when you have kids, when you have dependents, the conversation is way more critical than just who gets my stuff after I'm gone.
Absolutely. It's more than that. And as a new father myself of a 4-month-old, it's not just who gets my stuff and who will take care of them, but it's if I'm not around, what are the life lessons, the principles that I want to teach him and instill in him? And how can I go about doing that? And there's ways to incorporate and include that in your will. And it's not just, okay, my bank account gets divided. Here's where my, taxable account goes. Here's the beneficiary of my 401k and IRA.
So Mark, when you say life lessons, talk me through precisely what you mean there.
So let's say that you guys, it's always, second generation 5. If I pass away and let's say my wife remarries and I want her to be happy, and if that's what makes her happy, then so be it. But maybe they're not into pursuing 5 like I am, and they're a spender. Well, now they have all of the assets that I've passed to my wife and my son is going to grow up with this other individual, seeing how they are with money. But if I can leave documentation, leave notes, potentially leave audio or video recordings as part of my will for my son, he can now not only hear my voice, see my face, but hear and see the life lessons that I wish that I was able to instill and wanted to instill and teach in him.
Wow, that is fascinating. So, I mean, that makes sense to me on an intuitive level, but like, is that part of a legal document? Is that how this works?
It would be referenced in the legal document as almost a set of instructions or letters. It's not per se binding in the document. The court's not going to look at it and say, okay, we need to make sure that we teach this lesson on this date, so and so on and so forth. But they are included in there to be read for that individual and to teach them.
Yeah, this is neat. So, okay, let's just say we want to take this to the extreme and you want to almost like make a forcing function of 5 principles. Here's the pot of money. You can take out 4% of it every single year. Can you stipulate those type of things?
You can, but that would be outside of a will. And that would go into the trust that we'll talk about later on.
Okay, great. No, that sounds good.
What if it were even simpler than that? And maybe the answer is it's still a trust, but what if it's something like, hey, instead of a total lump sum windfall when I pass, I want this windfall to be distributed into, say, 3 parts, something at the age of 18, something at the age of 35, and something at the age of 45 or 55, whatever, pick a third number. But you hear about so many, lottery type winners that, a year later are bankrupt again. I don't know if that's really true, but anecdotally, I feel like I hear that.
I think it is. I just heard something yesterday about that.
Cool. Well, not cool, but for the purposes of this conversation, cool. For your kids, is that something that could you do something like that? It seems just a hair extra complex. Is that something that you could establish in the will, or does that also automatically move you to a trust?
That's going to also move you to a trust. One of the biggest differences is a will. Think of a will, things go outright. It's you get my shoe collection. You get Golden Boy. If you want to put...
Brad, is Golden Boy on the personal property disposition list?
It's probably not worth literally writing it on the sheet of paper.
I think there's some value to Golden Boy, but I may be a little biased there. But if you want to start putting restrictions or use kind of the carrot and stick approach to accessing the assets, you're looking at a trust.
Okay, so let's go ahead and do definitions of terms here. Wills versus trust, the difference. And then let's talk about wills first. What are the different components that make up a will?
So wills versus trust, again, the biggest thing is a will is outright. And even if you have a trust, you still will need a will because that is what is presented to the court for probate.
Probate. So that's another word that Jonathan and I both heard extensively in our our own estate planning sessions. Talk us through probate and why it's something you want to avoid so significantly.
So probate is really it's the judicial process that is your will is proved in the court, and it allows an opportunity for creditors to come and claim any debts that you might owe. And then anything that's left, any of those assets now are distributed in accordance with the terms of your will. Why people want to avoid it? It's a public process. It's expensive and it takes a long time. It could take 6 to 9 months on the short side on average.
Well, so is your money, let's say you don't have a will and your estate does go through probate, is your money locked up in its entirety for that entire time?
In a nutshell, yes. Each state may have statutes that allow, for example, in Florida, you can have an allowance that goes to the family if they need that. But otherwise, there is a separate account that's created. Assets are tied up. Accountings need to be reported to the court. Everything is recorded with the court, and the court keeps a tight watch on everything.
Mark, I'm trying to foresee an example where, let's say I pass away and all these assets are tied up. How does my wife pay the mortgage? How does she pay the bills? I mean, luckily, our accounts are jointly named, and I'm assuming that she would still have access to it, but I don't know. That's an assumption. I mean, can you talk me through that? Because that's like a real world issue. I mean, if I get hit by a bus, I don't want my family to lose the house because literally we just didn't have access to what's a significant amount of money, but we just didn't have access to it, you know?
Right, absolutely. So there's differences, and that was maybe too broad of a statement. There's probate assets and there's non-probate assets. If assets are jointly titled, if you have a joint bank account, those will pass outside of probate. Anything that's in your name individually, that's what will become a probate asset. Anything that has a beneficiary designation goes outside of probate and it's not tied up.
So to clarify, you have a bank account, you have a Vanguard account, whatever, but you've actually taken the time after hearing this episode to go make sure that your spouse or partner is titled as the beneficiary. That will automatically avoid probate as well.
And I would say automatically, as the legal answer is going to say, it depends. I have to, with the CYA for the legal stuff.
I knew that word automatically was.
But wait. For our audience, though, practically best practices are to make sure that a beneficiary is listed on all of their financial accounts.
Best practices is not only to have a beneficiary listed on all of your accounts, but in addition on your bank accounts, where you can't have a beneficiary, but you can have either a POD or a TOD. That's pay on death or transfer on death. What a lot of people do, and I'm going to soapbox here for a minute, so I'm going to apologize up front. People will list or add a significant other or a child as a co-owner on an account. That creates multiple issues. First and foremost, if that individual has creditors, those creditors can attach to the assets in the account. They also plainly just have access to the account. They can take assets out, no questions asked. If you place a POD or TOD designation in that account, it doesn't change the title of the account, the owner of the account, who has signing power and authority. What that does, it's equivalent to a beneficiary. When you pass away, your spouse or child goes to the bank and says, here's a death certificate. They had a POD and they issue a check. Still stays outside of probate.
Wow. So is that actually preferable to having a jointly owned account? Is that what I'm hearing, or am I misinterpreting this, Mark?
So I wouldn't say that, husband and wife, you want to have a joint account, that's fine. It's preferred over, let's say, a widowed individual naming a child or a other relative as an account owner.
Gotcha. Okay, that makes sense. Thank you.
So Mark, we've dropped a couple terms in here, and I appreciate you slowing down to define some of them. My personal phrase, personal property disposition list. But I was thinking maybe we could take a few minutes and talk about components of a will versus components of an estate plan.
Absolutely. So to make sure we're clear, components of a will, that is your last will and testament. That is one component of an estate plan, or as I like to call it, a life plan. But as far as the will, first and foremost, it's identifying who your family members are. Today's society, people are divorced, multiple marriages, multiple children. Who actually is an heir? We avoid situations like Prince, where they're still going through probate and you have unknown heirs and potential children coming forward saying that they're owed a share of the estate. You also can specify treatment of bodily remains. Do you want to be buried, cremated? What do you want to be done with your ashes? Next part, you have specific gifts of tangible personal property. If you want to specifically devise anything, you can put that in there. What's common is the reference to the list, the separate writing, as she just mentioned. And that way, if you sell something, you don't have to have your will amended, have a formal codicil added to it. You just update that separate writing. Then you make sure you have the catch-all net of your residuary estate, which is anything that I don't specifically devise to my spouse or my children. Here's where I want that to go. Then you appoint your personal representative. Well, at least in Florida, it's a personal representative. Other states, it's an executor or executrix for male, female. And you have survival provisions, which are super important to have. Not every DIY or off-the-shelf fill-in-the-blank will has that. So you want to make sure there's survival provisions. Then it's how do you want your obligations, expenses, and taxes to be paid? What are the powers of the personal representative?
So let's go through a few of those. I want to stop by just, highlighting the Prince case. So like one thing that's really important to consider with the will is that unfortunately, in many cases, when there is a lack of a will or an estate plan, your children often will end up with whichever entity is the loudest, right? I mean, like the ones that are making the most noise often end up getting the children. And this is just based on my recent conversations, that may not match up or mirror your actual intentions. So like at the base level, this will is going to make sure that your children end up with who you want them to end up with, right?
Correct. That's a provision you put in here. But in addition to that, and what I've done for myself personally and recommend for my clients is to not only include that in your will, but have a standalone designation of pre-need guardian. And again, at least that's what it's called in Florida. Your state may call it something different. What that is, though, is let's say that you are in a car accident and your wife is traveling. Now, who's going to pick up your children from school or daycare, wherever they are at that time? Because you're in a car accident, you're incapacitated, your spouse isn't there. Legally speaking, there is no legal guardian. They would become a ward of the state. Your parents, their grandparents may be on a pickup list at school, but that's going to be a saving grace for that short hour window or short period of time. Legally speaking, they won't be able to do anything else with that child. So a standalone designation of pre-need guardian goes in place of the will where you're still living, but you are incapacitated and cannot care for your children.
Wow. So yeah, that's a document that I've never heard of. So yeah, I mean, in our will, we do have an appointment of guardians if my wife and I both do pass away. But yeah, so you're saying this is a very special case, but it sounds equally as important to have. I mean, that's not implausible at all.
Correct. Yeah. And Brad, let's say that you and Laura are on a point redemption trip and...
Well, let's keep the points out of this, huh?
Well, you guys are on a trip. How you pay for it is a separate...
They made the mistake of paying cash.
Sucker.
You guys are on a trip. Something happens. You end up being okay. Everything is unicorns and rainbows. But in the meantime, who is going to be the legal guardian for the girls? And you can appoint a temporary as well as a permanent legal guardian so that they don't become a ward of the state.
So this speaks to incapacitation. They just can't get back. There is an extended separation and now legal stuff has to happen. And in a vacuum, no one has permission to take care of these kids. No one can take these kids to the doctor's office because they don't have the documentation necessary to fill out the forms if you don't have this in place.
Correct. It's that. And let's just say maybe they're local and you guys are on a road trip and you're in a car accident and you're in a coma, you're incapacitated. But again, you're still alive. So your will is not quote unquote activated. No one is going to look at your will. Your will does not govern and is not binding, but this document would be.
Yeah, that's really good information, Mark. So random question, because this guardianship, I mean, this is one of the most essential pieces of a will. I mean, clearly you would hope that you had in-depth conversations with the people you name as guardian. But I mean, are there ever oddball instances where like someone's listed as a guardian and they either don't want to or cannot take, I guess, this guardianship of the children? Like what happens then?
Absolutely, that happens. And it's not necessarily just that they haven't had that conversation. Maybe, I've had the conversation with the guardian that I've elected for my child. And today when we had that conversation, they could take care of him. But in 5-10 years, if something happens, their life has changed substantially and now they can't. That's where I recommend having multiple guardians. You have, here's my first choice, here's the successor, and here's the alternate successor. And additionally, if you have someone that you appoint and they don't live locally, it's imperative to have someone that does live locally and appoint temporary guardianship to them so that in the duration it takes them to travel to get to where the children are, they don't become a ward of the state for that 4, 5, 6 hours, 24-hour period.
Oh, I didn't do that. Mine.
Yeah. I've a couple of screw ups already on my document.
Well, they're not screw ups. You're still living. You still have your capacity for the most part, so you can still amend it.
There you go.
Okay. And Mark, so that's actually in the will itself, not in that separate document, or in both. Is that what you're saying? The successor guardian, and also that instance where you just need someone for a very short period of time.
So I put them in both, but it's especially imperative for that temporary guardian in the designation of pre-need guardian document, because that, again, is a situation where you are still living, but you're incapacitated. You're not giving up all guardianship, all rights to continue raising your child.
And now you said ward of the state a couple of times. Just real quick, I don't want to get bogged down on this. What does that mean in practice?
So they would go into DCS, or Department of Child Services, and effectively kind of quote unquote go into the system. And they are they're an obligation of the state. That's kind of the term the ward comes in. The state would act as their parent or guardian until someone else is appointed.
Right. So something to avoid, obviously, if you can, if it just means adding an extra line into a document that you took such care to create already, right?
Correct. And there's nothing against DCS and what they're known as in other states and people that have come out of the system or have been wards of the state. It's just, as a parent, again, if I can avoid that situation, I would prefer to.
So, Mark, we've been talking extensively about the components of a will. What if we expand outside of that framework and we talk more about the estate plan? What other documents are a component of a solid estate plan?
Absolutely. Great question. So, and that's, again, I've mentioned life plan a few times. I refer to it as life planning just because I think it reframes the conversation. Estate planning, again, you think of the sprawling estate and death with your will. With life planning, so the other documents that I include, in addition to the last will and testament, you have a power of attorney, a healthcare surrogate that includes a HIPAA release and authorization. You have a living will, and again, that designation of pre-need guardian. And then, if need be, depending on the situation, there's various types of trust that we can include.
All right, Mark. So yeah, you mentioned a bunch of documents in there. It sounds like many of them are healthcare related, right? A HIPAA release, healthcare surrogate. You might have mentioned one other. Talk me through what someone needs to consider with those specifically.
Absolutely. So yeah, there are quite a few that are healthcare related, and that's thanks to HIPAA and how protected and private everything has to be. So with healthcare, you have, again, the healthcare surrogate, or in some jurisdictions, it's a medical power of attorney, as well as the living will. What those both do is, if you can't make healthcare decisions for yourself, you're appointing someone to make them for you. And that's specific to the healthcare surrogate. With the living will, if you have, a terminal condition, an end-stage condition, or a persistent vegetative state, think of Terry Schiavo situation down here in Florida, that would have prevented that situation if there was a living will in place. While you have your capacity, you're saying, here's the level of care that I want in these situations, or here's the care that I do not want. And then financially speaking, there's the power of attorney, and there's various types. There's durable power of attorney, limited power of attorney, general power of attorneys. I mean, I could talk about that for a while, but I don't want to get too bogged down and lose all the listeners here.
All right, cool, man. Well, you mentioned trust a second ago. I think this is the perfect transition for us to kind of figure out how to connect those two. We basically teed up at the beginning of this segment talking about how a will is just, it's a one-off execution of your wishes, where a trust basically gives you the ability to dictate your, wishes over an extended period of time, in particular if it's more complex. But whereas with a will, you're going to have someone executing the will and then it's done. A trust, you can have someone looking after it over a period of time. Is that the biggest difference?
Yeah, one of the biggest differences, exactly. And again, you keep the court out of it. A trust is private. It's known when someone passes away that there is a trust, but the actual terms of it, how things are dispersed, who the beneficiaries are, those are not known, whereas they are in a will.
Okay, so just to clarify, as part of a will, the net worth, the assets that are being distributed, who's getting custody, all that stuff is part of public record.
Correct. If you go on Google, for example, Elvis or James Gandolfini, you can see the named individual that gets what specific asset. Actually, I think even in James Gandolfini's will, he set up a trust for specific individuals, and you can see exactly the amount of assets that went into that trust.
Wow, that is crazy to me. So, okay, hold on, Mark. I want to make sure I'm not missing something. How do you avoid that entirely? There is a way to avoid that, right? Because ideally, we don't want everybody knowing what assets we're passing along.
Correct. You can avoid that, again, with the beneficiary designations, the POD and TOD designations, as well as transferring assets into the trust while you're living.
While you're living. Okay. So if it is part of the will, if you have a trust set up as part of a will, then it is part of public record. But if you're saying while you're living, that's a separate thing, and then it's not reported anywhere.
Correct. And the way that those would work in practice is you have a pour over will is what it's known. Think of a cup of water and a pitcher of water. Your last will and testament is the pitcher. The trust is the cup. Anything that's not specifically devised out in the will, we are transferring over into the trust.
So, Mark, I'm really interested in actually talking about why you might actually want a trust. Before I actually started looking into my own estate plan, I basically thought that, wills are basically for everybody and people would do trust if they wanted to avoid estate tax. But, then I Googled, hey, what is the estate tax limit? And for married filing jointly, it's like $22+ million. Like everything under that amount isn't subject to the estate tax. So that doesn't really seem like that is going to describe very many people in our audience. Certainly doesn't describe me, but it sounds like you're making a case based on what we talked about earlier that other people would benefit from looking into a trust, even if their net worth doesn't approach $10 million plus.
Correct. Yeah. And with that estate tax that high, very few people are impacted. There is a possibility of that changing in 2025, but there are a lot of other benefits out there besides avoiding that estate tax. One of those is, again, if you own your property and you pass away, if it's jointly titled with, you and your spouse, now when it goes to your children, they may be able to continue living there. But if they want to take out an equity loan, if they want to sell it, they can't actually do that because they're not on the title. Your house now you have to go through probate to clear title on that house. And if you want to sell it out of probate, that's even a longer process to keep the court involved. Whereas if you set up a trust and transfer ownership of the house into the trust, now when you pass away, your successor trustee steps up. Now they are the owner of the house. They can sell it, do whatever they want. The court is no longer involved with that. That's one of the biggest benefits where you're not concerned about what is your overall net worth, but your concern is just to avoid probate.
So, Mark, I'm trying to understand because I guess in my newly drafted will, I have what looks to be, I don't know, there's like an Article 3 residuary estate. And this looks like where the trust is set up. But I don't have any like formal trust documents. I didn't form an entity. I didn't do any of this stuff. So I'm not sure if what I have is what you're talking about. So could you just talk the audience through like, is this trust formation? Is this a formal thing now? Does it happen upon death? Are there multiple options? Give us a real sense, because I think this is real significant stuff here.
Yeah, absolutely. So there are different types, and without seeing what you have, it sounds like it's a testamentary trust where your will effectively sets up a trust upon your death. So you would still go through the probate process. To a certain extent, assets would be known that are transferred into the trust. And actually, the terms of the trust are likely set out in the will. So the terms of the trust would also be public record. Versus setting up the trust today, that's a living revocable trust. You transfer assets and ownership in the name of the trust. So it could be, the Barrett family trust.
So let's dive into that a little bit further. The first, which was the testamentary trust versus the second, the living revocable trust. Pros or cons? Why would you? I'm personally trying to understand why you would pick one over the other.
So with the testamentary trust, it's likely a more cost-effective option because you're not having to draft a trust at that same time. The con to that, though, is it's all public record. When your will is filed, the assets that are going to the trust, the beneficiaries, the distribution to the beneficiaries, that's all public record. Versus setting up a living revocable trust, you transfer assets into the trust while you're living. And again, it's revocable. So if you decide to move things out, sell it, you can do that from there. But upon your passing, the title is already in the trust. So now the successor trustee steps up. They continue to operate or use the assets as needed, and it doesn't become public record. The court is not involved.
So living revocable trust. Okay, you would describe that as like the Barrett family trust in my instance. Now, if I'm moving assets in there while I'm still living, what am I putting in there? Like, I'm assuming I'm not putting my checking account that I'm using to pay in and out of. Talk me through examples of how you would advise someone, or if you would advise someone to move their assets in based on them still living their lives financially, right?
Right. And what I typically advise most of my clients is their homestead. And again, Florida, the laws are different than other places, but you still maintain that homestead exemption, even transferring it into a trust in Florida. So they transfer that homestead property into the trust. So that's there. As far as their other everyday accounts, we set up either a beneficiary designation or the POD and TOD designations so that those pour over into the trust upon their death.
Okay, that makes sense. So, and now just for clarity's sake, testamentary trust, that's what you're fairly certain that I had as part of this will that I just had drafted. It seems like I'm able to give direction on when the assets are passed out to my children. So that seems to be the big plus to me. Are there negatives? Are there other positives that I'm missing? Like, talk me through why someone would do that as part of their will.
Yeah, so I think one of the biggest positives is it's more cost effective to do a testamentary trust than a living revocable trust. And again, if you don't care that it's public record, that's fine. One of the biggest unknowns or questions with that really is you may not care, but now your child, they know exactly when they're getting X number of dollars. Arguably, in either situation, the language could be up to the trustee's discretion. But more importantly, if let's say, there's a distribution at 25, and I'm just making this up, what if one of the girls has a creditor and they know that she is getting X number of dollars on that birth date? They can attach to that future interest. And now it technically does not go to her. The creditor has that interest claimed already. If it's in a living revocable trust and it's up to the trustee's discretion, maybe that distribution is given, maybe it's not.
I actually want to talk about the maintenance of these trusts, or really more specifically, the execution of these trusts, because this isn't like a passive process. Even if you just have a will, if you're not talking about a trust, you have a will, then you have someone that has to carry this out. That's actually part of setting up your will. Who do you want to execute your will? I'd love to get your thoughts on that. But with the trust, it's more than that, right? This is not just a one-off responsibility.
Correct. Well, yes and no. It's a one-off responsibility in the sense when you set up a living revocable trust, because you and or your spouse are the initial trustees. So you are carrying that out while you're living. And now it becomes a larger responsibility for the successor trustees upon your death or incapacity. But as far as a will is just a one-off.
Mark, I appreciate the detail that you've dived into with us on all these different topics. And I think it would be fair for our audience, let's just get a sense for what this is actually going to cost to have a lawyer look this over and help you prepare this estate plan. I acknowledge that you very likely can go download some templates off the internet, either for free, if you do enough searches, or, for minimal cost, $100, $200, something like that. But to have a lawyer come sit down with you and your family and create a will or trust, assuming that it's relatively simple, there's not a ton of extenuating circumstances, what is the cost range for that?
So yeah, the cost can anywhere from $1,000 to $2,000, but I've seen them upwards of $10,000, $20,000+. But again, for that, you're looking at multiple types of trusts, and they're not just your standard living revocable trusts. They're separate, smaller, different nuanced trusts. But it is there's a range of costs, but I would say that $1,000 to $2,000 is probably a fair range.
Cool. And of course, that's going to vary depending on where you live, et cetera, your situation, the exact documents. But yeah, for the audience, that's just a nice range to, okay, roughly somewhere in there. That's what it's going to cost to get, like you said, the power of attorney and maybe an advanced medical directive and a will, right? Is that somewhat accurate?
Correct. And then, maybe they do, again, we mentioned the designation of pre-need guardian. And then, do you need planning for your children as well?
So we've spent a lot of time actually talking about setting up a will or trust, but ultimately, you're not going to be the one executing this will. And that comes to mind because obviously, as part of setting these up, you need to be thinking about this. You're going to have this 40-page, set of documents that gives out your directives to the world after you pass potentially or are incapacitated. How do you recommend that someone think through who should be the executor of the estate? Is it just whoever is going to be a guardian of the child, or is it more nuanced than that?
I would say it's a little more nuanced than that. And especially with children, you can have not only just the guardian of the child, you can have two separate individuals caring for your children. One is the guardian of the person, or actually caring for your child physically, and the other one, guardian of the property, caring for the assets. Maybe someone is more loving, someone else is better with finances, but there's not that one person that's great at both. You can separate that for your children. But to get back to the original question, as far as who to appoint as an executor or personal representative, that is someone that you trust, that will honor your wishes. And not only that, they're held to a fiduciary standard. And if they don't go along with what you've put in there, they don't follow those instructions, they are personally liable. But most importantly, they have an attorney assisting them throughout the process. So they're not on their own. How do I do this? I've never done it before. they can call a professional to help them through the process.
And can you even set up in the will or in the trust, like instructions for, hey, maybe you don't have to use this person, but I would recommend you reach out to this person, this attorney to help you execute this will?
Absolutely. And it is up to that individual when they execute it. Do they want to go back to the attorney or law firm that drafted it? Do they want to go to someone else? Oftentimes with spouses, maybe one of them liked the drafting attorney, maybe the other one didn't. They may or may not go back to them.
And that's actually a question I had is how involved are you as the drafting attorney going forward? Do you keep a copy of these signed documents in your file? Like, what if someone loses their will? Like, I'm imagining a bunch of different scenarios. How involved are you going forward?
Absolutely. So what I do personally, and again, a lot of firms are different. Each firm has their own way of doing it. I give the originals back to the client. I keep digital copies just in case something is lost, can't be found. But the originals go back to the client so that when one of those documents is needed, when they pass away, they reach out, contact, whether it's me, contact another attorney, they have that original will to file with the court. And I also do that again. I would love for them to come back to me and let me assist through that process. I don't want them to feel an obligation to do that.
And if you have this testamentary trust that is set up upon your death, and in particular, this trustee is now following your wishes over this period of time. And in this testamentary trust, you said, hey, I want my assets to be given to my heirs, in 3 parts over a period of, 20 years or so, or 15 years, whatever that may be. That is 3 or so touch points down the road. What fees or costs are associated with maintaining those accounts over the period of time?
So from my perspective, there are no additional fees. Again, I'm drafting it and putting it in place. If it's a living revocable trust, the client is serving as trustee. Technically, they are entitled to fees. I guess they could pay themselves from their own account and just wash money in circles like that. But successor trustees, alternates, once they are appointed and step into that power position, they are able to collect a fee. But as far as the ongoing process, and even with a testamentary trust, there is no maintenance cost for me. If things need to be updated, there's a cost to update, but there's no ongoing maintenance cost. It's not like fees with an advisor or anything like that. Now, if they go to a corporate trustee, they do have fees where it's often a percentage of assets.
So Mark, in there you mentioned something about updating, and that was actually a closing question that I had. How often should you revisit these documents? Like I had a 10-year-old will and set of estate documents, and I just wanted to look through it, get a new lawyer to take a look, see if anything needed to be updated. But I don't know, honestly, if I really needed to do that at the end of the day. Like not all that much changed, but how often would you advise people to look at it and then to potentially revise documents?
Right. So my rule of thumb is I reach out to clients every 3 to 5 years just to see if things have changed. But in that time frame, maybe they've been divorced, maybe their children have gotten married, they've become an adult. I don't know, obviously, their life situation. I don't keep track of all that. I rely on them to reach back out to me. But every 3 to 5 years, I'll contact them for a review. Has there been changes? Do we need to do any updates?
Yeah, great. That's very helpful. And I'm just curious, where do you advise your clients to literally store these documents? Is this a fireproof safe? Do you put it in a safe deposit box, or is that not advisable? Where do you actually tell them to store these things?
I give my clients, they have a leather-bound binder to keep with them, but I do advise against a safety deposit box for the primary reason, again, at least in Florida, if they pass away and they're the only person listed on that safety deposit box, maybe their children have a key, but if they're not listed as account holders or having access, I now have to petition the court to get into the safety deposit box, have witnesses, record everything. Again, it gets filed with the court. It prolongs the process just to see the will.
So Mark, we talked about the cost range. And I guess one of the questions I want to ask, just because we are a DIY community, who can get away with the DIY will? And let me just make this even easier by giving you my kind of unfiltered perspective on this. In my opinion, someone, if you're relatively young, you don't have dependents, you don't have a significant net worth, you don't have property, you don't have a spouse or a partner, the simpler your life is, the less important it is that you get everything perfect, right? Just because there's not as many people that have to deal with the distribution of your stuff, and more importantly, your children after you're gone. As you start to have a family, you start to have property, you start to have assets. All of these things make the will more and more imperative, and it also raises the stakes. It makes it more critical that you get it right, which, if the choice is just binary, a will, no matter how simple, versus no will, we'll just do that. But the importance of making sure that it's right really is elevated as you start to have people that you will be leaving behind. As you have children, as you have family, the importance of making sure that you have it locked down and have it done right becomes more important. And when you feel that way, or you sense that that is really the case, that identifies your situation, it's probably time to bring an attorney in and have them help you make sure that you have a solid plan locked down. Is that fair?
I think that's incredibly fair. I mean, I would say even for the 18 to 20-year-old with, just the TV, I would say it's still worth going to an attorney, taking advantage, and I hate to say it that way, but taking advantage of the free consultation, see what options are out there. Maybe your life isn't as simple as you think it is, but that would probably be who I would blanket statement say could get away with the DIY. But as you said, if you have anyone depending on you, own property, have children, it's imperative to go to an attorney. These DIY sites, if you look at their disclaimers, they tell you up front they're not an attorney, they're not a substitute for an attorney, and they don't provide legal advice. They're just self-help forums based on your knowledge.
And I'm perfectly happy to DIY everything myself, but when it comes to my kids, the bar's got to be a little bit higher. So, hey, Mark, this has been so much fun. And on most shows, that would be the end of the episode. But on this show, we would love to give you the chance to tackle the hot seat. Are you ready for this?
Oh, boy, I've been waiting for this one.
In a world drowning in debt and rampant consumption, trapped by the chains of lifestyle inflation, these questions highlight the secrets of those who have broken free. Welcome to the Choose FI Hot Seat.
All right, Mark, question number 1, your favorite blog that's not your own.
I hear a lot of the same responses. I feel like I'm going to be a little unique when I say this, and actually Choose FI.
Oh,
I really, really enjoy that. And I have to give a shout out to my wife. She started one of her own blogs. I enjoy that as well, but I'm a biased in why I enjoy that.
All right. Well, let's hear. What is the name of your wife's blog?
It's millennialmomconfessions.com.
I like that.
How long has she been writing for?
She's been writing for about 6 months. We just made the transition to her being a stay-at-home mom. And she's always wanted to write and loved writing. So she's trying to pursue that passion.
Awesome, man. Well, we'll link to her blog in the show notes for today's episode. Question number 2, your favorite article of all time?
I'm going to have to give this one to Andy Hill's article, How Fatherhood Sparked My Desire for Financial Independence. That one really hit home for me, as I found that right when we were trying to have a child and really got me on this road.
That's great. I've never read that article personally, but yeah, definitely want to check it out. And obviously the sentiment I can certainly understand and appreciate in my own life. So yeah, that's really great. All right, Mark, question number 3, your favorite life hack.
I'm still searching for that, but you guys have good suggestions every week. But currently I would say it would be not procrastinating and utilizing credit card points and miles as best as I can.
Nice. Have you taken any cool trips yet?
I have not yet. We just booked our first one, though. We are going to Utah for a week. It's my wife, myself, my mother-in-law, and our son, all going out first class, and booked on Delta using Virgin Miles.
Oh, wow. That's very impressive, Mark. Good for you. And first class. That's a nice way to do this the first time.
Yeah, I haven't pulled that off yet, man. It's still
we're trying to do it nice the first time.
Cool.
All right. Question number 4, your biggest financial mistake.
With the rose-colored glasses, I'm going to say my biggest financial mistake has yet to occur. I think I've made some, but trying to take the viewpoint that it's just money. We can always make more of it down the road, but to enjoy this life as it occurs.
Well, I hope that if you haven't had any big financial mistakes up to this point, that you don't start out making one tomorrow or next year, man. Maybe you're just going to get a free pass on the entire thing.
Well, when I get to that point in life, I'll look back and then find that financial mistake. But hopefully I don't make it in the future.
All right, Mark, question number 5, the advice you would give your younger self.
Pay attention to opportunities earlier, especially, specific to context of this show, opportunities to invest. Compound interest is such a powerful vehicle that I don't think I realized early on as much as I should have.
Awesome, man. And we do have a bonus question for you. The purchase that you made over the past 12 months that's brought the most value to your life.
As cliche and corny as this sounds, it might be a set of erasable pens that I bought off Amazon. I still use an old school pen and paper calendar, but as appointments change, it's nice to be able to erase that and not just have arrows and strike throughs everywhere.
Awesome, man. I realize that being an attorney and doing estate planning is a very localized business, but I'm sure there are people listening to this from Florida that are going to want to reach out to you and find out more about how to have you come in and help them with an estate plan. What is the best way for someone to connect with you?
Absolutely. They can reach me at my website. That's markmosslaw.com, or I am on Facebook at Mark Moss Law and Instagram and Twitter at Estate Plan Jax. That's JAX.
All right. We'll have links to those in the show notes for today's episode. Mark, thanks so much for joining us on the show today. We have really appreciated your insight into this somewhat complicated world of estate planning.
Absolutely. I really enjoyed it, guys. Thank you very much. Keep doing what you're doing. Keep that fire spreading.
Brad, this was a deep dive into the world of estate planning. And while I don't know if we hit on every nuanced aspect to the process, I certainly feel like it gives both me and you a foundation personally to speak about it in the future. And honestly, a great place for our audience to figure out whether or not, one, what they have currently is sufficient, or two, what actions to take in the future.
Yeah, this was really helpful. I appreciate Mark's time and his expertise. And yeah, this is just important. And I think people need to pay attention to it. If you have assets, if you have dependents, if you have people who rely on you, you need to give them directions just in case the worst happens, right? I mean, this is really important stuff. And to you, the audience, if you have further questions, Mark is a member of our community. He said he'd gladly follow up. So yeah, let's get some threads going in the Facebook group, and maybe we can have him back on for Friday Roundup to follow up on this.
All right, if you got value from today's episode, if you've been getting value from the episodes up to this point, just take 1 second and press the subscribe button on the platform you're listening to this on. It just lets the providers know you're getting value from the show and you want to be here when we produce additional content. If you want to support us in what we're doing here at ChooseFI, here are 4 easy ways. 1, leave us an iTunes review. To do that, just go to ChooseFI.com/iTunes. 2, use our page to sign up for travel credit cards. If you want to travel the world with miles and points instead of your hard-earned dollars, then just go to ChooseFI.com/cards and get started today. 3, if you're working on the milestones of FI, set up a personal capital account to track your progress and use our affiliate link. It's completely free, and just go to ChooseFI.com/PC. P as in Paul, C as in cat. And 4, and most importantly, find your friends, coworkers, and family members who might be open to this message and tell them about the podcast. Have them start with episode 100. It is a fantastic starting place. All right, my friends, the fire is spreading. We'll see you next time as we continue to go down the road less traveled.
You've been listening to Choose FI Radio Podcast, where we help middle-class America build wealth, one life hack at a time.